Now we'll hear from the appellant.
Good morning, and may it please the court. I am J. Noble Grant III, a member of the Jackson-Madison County Bar Association, and I represent the appellant, Erin Elizabeth Enfinger. At this time, I would like to reserve 3 minutes for my rebuttal argument.
All right, sir. You may proceed.
Thank you. Well, as always, it is a pleasure to be before this court. We are here today on a paternity action that was tried before the Juvenile Court of Chester County, Tennessee. And before I get into my argument, I would like to point out a couple of incorrections in my brief that I found when I was preparing for my argument today. On page 16 of my brief, in the second paragraph, after the second sentence of that paragraph, I have an incorrect citation. I have cited to id right there, and this is important because it has to do with father's testimony about the potential effect that the name change would have on his relationship with the child. The correct citation that should be in that place is to volume 2, page 27. I would like to point out one other correction, and it is found on page 25 of my brief. About a third of the way down that page, I have stated an incorrect amount for the total medical bills that were submitted to the trial court. I've got $6,043.37, and that amount should be $4,062.56. So with those corrections mentioned, I will now begin my argument. As I said, this was a paternity action, and the trial court was deciding a permanent parenting plan for the child. The action was initiated by the father with a pro se petition to establish paternity and a parenting plan and for a change in the child's birth certificate. I would like to mention that the petition itself does not reflect what name the father wanted the child's name to be changed to. That issue is, I would argue, one of the most important issues in the appeal. The trial court, what we would contend, made insufficient findings that a change in the child's surname from the mother's surname of Enfinger to the father's surname of Knipper, the trial court made insufficient findings to change the name, and the statutes that deal with that issue, child was born out of wedlock. The statute says that a child born out of wedlock must reflect the child's surname as that of the mother, unless both parents have requested otherwise. Now, in order to change that, it is upon the party, the burden is upon the party seeking the change. And this court has held that the amount of proof required to justify a change in the child's surname is not insubstantial. Minor inconvenience or embarrassment is not sufficient. The Tennessee Supreme Court laid out this court laid out the factors in the Barabbas case for the court to use to determine whether a change in the child's surname will be in the child's best interest. And those factors, as this court is well aware, are number one, the child's preference; number two, the change's potential effect on the child's relationship with each parent; number three, the length of time the child has had its present surname; number four, the degree of community respect associated with the present and proposed surname; and number five, the difficulty harassment, or embarrassment the child may experience from bearing either its present or its proposed surname. Now, the trial court in this case relied, I would submit, heavily on some litigation that preceded the current action. My client, Ms. Enfinger, the appellant, was a minor child at the time that this action was litigated. Her mother, Maria Enfinger, the maternal grandmother, filed a petition for order of protection on my client's behalf prior to father's initiation of this parentage action. The order of protection was not mentioned by either litigant at the trial in this cause. The order of protection was brought up sua sponte by the trial judge himself, and the petition, the temporary order of protection, and the dismissal of the order of protection were all entered as an exhibit in the trial by the trial court itself.
But excuse me, counsel, the trial court introduced it?
The trial court took judicial notice of the petition for order of protection, the ex parte temporary order of protection, and the dismissal of the order of protection. Neither party moved to introduce those as an exhibit at trial. The trial court sua sponte made those an exhibit to the trial court record.
Okay.
And that is important because it appears from the record, and I was not involved at the trial. I got involved after the trial and filed a motion motion to alter or amend the court's order, and that was when I became involved. But it appears from the trial court record and the trial court's order from trial that trial court relied heavily on the fact that that the appellant sought this order of protection, and in the trial court's words, the appellant and her mother, the grandmother, did whatever they could to keep the father from being involved in this child's life and parenting this child. But there was very, very scant testimony about that at the trial court level. There were some allegations made by father during his testimony. Those allegations were disputed by mother in her testimony. So but notwithstanding, it's clear from the record that the trial court relied heavily on that proof and the proof that preceded this action. The trial court's order ordered that the name be changed from Enfinger to Knipper. And the trial court's order, when referencing the name change, the basis for that was, and I'm quoting from the trial court's order from trial, quote, "The last name of the child shall be Knipper, based firstly on the brother of the mother who has a felony conviction, and secondly, the changing of the name to Knipper might influence mother and grandmother to cease their attempt to prevent the father from seeing his child. The court rules that a change in the name of the minor child is in the best interest of the child." That is the only—
Counsel, let me ask you a question. What was the evidence about the brother's criminal conviction?
So the evidence about the brother's criminal conviction, there wasn't any evidence as to what exactly the criminal conviction was. The mother—
was it a felony?
What was that?
Was it a felony conviction?
It was a felony conviction, and actually it's a half brother of the appellant, not a full brother, a half brother of the appellant. There was some testimony that he had spent or served, mother testified she believes 3 years in prison. And the grandmother was asked if he had served 6 years in prison, and she answered that she did not know. There was no evidence as to what the conviction was. It was just that it was alleged to have been a felony, but nobody knew for sure. Mother just testifies that she believed he served 3 years in prison. But there was no testimony about what effect, if any, that felony conviction had on the reputation of mother in the community and the reputation of mother's surname in the community. There was no testimony as to where this half-brother even resided, whether or not he resided within the community that the parties reside or whether he resided elsewhere. There was absolutely no testimony that this felony conviction of the appellant's half-brother had any effect on the reputation of mother's surname in the community in which the child resides down in Chester County, Tennessee. And that would bring me to the point that this court has previously held that the amount of proof required to change the surname is not insubstantial. I would argue that the felony conviction portion of this that the trial court relied on is very insubstantial proof based on the evidence that was introduced at trial. It's not enough proof for the court to have changed this child's surname. It's not enough proof for the court to have found that mother's surname is disreputable in her community, such that it would prevent the child from carrying mother's surname because of embarrassment or harassment or any kind of disreputable, any bad reputation of mother's surname. So, and the only other reason that the trial court gave, like I said, was that, if I can find my place again real quick. The only other reason that the trial...
Counsel, you've used your initial time. You've reserved 3 minutes for rebuttal.
Okay.
All right, we'll hear from the appellee.
May it please the court, I'm Mary Jo Middlebrooks of the Jackson-Madison County Bar, and I represent the father, William Knipper. Let me give you a little background in terms of dates. On June the 6th of 2017, the grandmother filed an order of protection in Chester County alleging rape on the part of Mr. Knipper, and it was Judge McKenzie who heard the order of protection. He dismissed it on July the 13th, and in his order in this case, he said that mother actually admitted that the purpose of the order of protection was to keep father away. Then on July the 15th of the same year, 2017, this child was born. 2 days later, Mr. Knipper filed a pro se petition to establish parentage. I was employed in December of 2017.
Excuse me, I'm back. For some reason I came out of the Zoom. Can y'all hear me?
Yes.
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 I can't see anyone.
We can see you.
We can see you, yeah.
Might
Okay,
have
let me-
minimized the window. You might need to bring.
Oh, there I am. Can you still see me?
Yes.
You
Okay, I'm
can,
back.
yes.
I'm back. All
You're
right,
looking
thank you.
good.
I'm sorry.
Counsel, let me ask, how old was the child, the mother, at the time of conception?
She was a minor
What was
in
her,
high school.
what was her age?
She was a senior when this was heard, and on June the 7th of 2018. So she would have, at the time of conception, she was probably either a sophomore or just starting her junior year.
So she was roughly 15 or 16 years old. Is that right?
16 or 17, I would say.
And how old was the father at the time of conception?
He is 4 years older than she is. So
Just 4 years older.
he had already graduated.
Okay, all right, thank you.
Mhm. The,
While we're here and at sort of a break, I understand, I think I understand where you're going with the chronology here, but is it appropriate, is it permissible for the trial court to consider what he heard regarding the order of protection and sua sponte interject that into the paternity action?
I will tell you that both Ms. Snyder and I were surprised. So neither of us knew about that hearing. If you can believe that neither of our clients bothered to tell us.
Oh, yes, I can believe that.
And so, and I really think that Judge McKenzie asked us about marking those as an exhibit, but I can't be absolutely certain about it. I mean, there was a discussion about it, but I think if we had, we could have brought that information to the court if we had known about it, certainly. And my client would have testified more expansively about mother and grandmother keeping him from the child, but it really wasn't necessary because Judge McKenzie knew it. And certainly what he knows is a matter of record with the court. So if he had not, like in Jackson, if the order of protection had been heard in Judge Harvey's court and then this hearing was in Judge Little's court, we would have obviously brought in more information about all of that. It just wasn't necessary with Judge McKenzie because, he brought it in. And the grandmother tried to get criminal charges on a number of occasions brought against him for rape, and also tried to interfere with his parenting time through support services. So
I understand that that's what happened.
right.
My question, though, is it permissible, since we're talking about two different cases? We're talking about an order of protection, then we're talking about a paternity action, and the court seems to have at least introduced its own evidence, or that apparently that, according to Mr. Grant, that's what seemed to happen. So
He did bring it to our attention, certainly, about the order of protection. But actually, I guess, other than the fact that the grandmother is not actually a party in this action, we're still talking about all the same parties in the same court with the same judge. And I don't see any difference there than if you come back on a let's say a post-divorce action with the same judge, they're going to look at what the history of the case has been. And all of this was very fresh with Judge McKenzie. And he made it very clear that in a 40-year period on the bench, he had not seen the kind of action that he had seen on behalf of the grandmother and the mother in this case.
Well, I think perhaps the difference may be, and I could be wrong about this, in a post-divorce action, you're probably filing under the same case number and you're continuing on, and you've got the file in front of you, which you can look at, which is, I don't think there's a problem with that. In this, I doubt seriously, or I would be surprised if the order of protection action had anything to do with the paternity action, since we're dealing with two different types of cases and two different types of filing. So what are your thoughts on that?
Well, I think Judge McKenzie specifically found that it did not have to do with an order of protection, that it had to do with the grandmother and the mother trying to keep the father away from the child and not being involved in the birth of the child or anything involving the child afterwards. He wasn't allowed to go to any prenatal conferences with the doctors or anything. He was totally kept out of the life of the child, both before the child was born and after.
Is that evidence that was in the paternity action or evidence that was in the order of protection action?
evidence in the order of protection action. Now, my client,
Was that also introduced in the paternity action?
no, my client did testify briefly about the problems that he had been having with them. But again, Judge McKenzie made it clear on the front end at that hearing exactly what had happened. And I didn't see any reason to go through it again with him because it was clear Judge McKenzie knew exactly what had been going on between the parties. The only thing I can tell you in terms of it being a different case is if we had an order of protection in Chancery Court, it would be in a different file. But we often talk about them because it's the same parties, just like they were the same case, it just carries a different number. So again, I think all of this happened all at the same time, the time period involved, and therefore it is the same case. All the facts are the same, the parties are the same. We've just got two docket numbers, basically. There was no difference because there wasn't a need for an order of protection. And it was dismissed, and Judge McKenzie made it pretty clear why he dismissed it. About the name change. This pro se petition by father was filed 2 days after the birth of the child. There wasn't even a birth certificate at that time. So it technically, at that point, it wasn't a name change. It was what name is a child going to have? And so the main thing about all of the issues raised in this case, of course, is the requirement to prove an abuse of discretion. And it is clear that there was a felony conviction of a family member. It was a felony. The half brother had served 3 years incarceration. And, this thing about, I don't know what he was convicted of and all of that. This is a very small community in Chester County. And my client did refer to them as just wild, but he clearly did not want to bash anybody. He wanted to have a good relationship with at least the mother. I think the grandmother is a lost cause, but at least the mother, and did not want to talk about them. And so the issue here is the blatant hostility of the grandmother and the mother against dad, and the judge finding, because the Barabbas, all of those don't even apply in this case, each of those 4 factors, because this is a very young child. And usually when we're arguing.
Well, let's hold on a second.
Okay.
What's your authority for that Barabbas doesn't apply because this is a very young child?
Well, for instance, it's how long has the child been using that name? This child, at the time we were arguing this, was about 1 year old, doesn't even know what the last name is. And most of them
did the child not have a name at that point in time when you were arguing it? Yes.
But the child's not being like going to school and being referred to by that name. But those factors in Barabbas it's not those 4 and nothing at all. The judge can certainly say that he's adding another reason that he finds in this case, and that was to try to influence these 2 women to promote a relationship with the father.
How does that work?
Well, Judge McKenzie's been sitting on the bench 40 years, and he thinks that would help. And I don't know that that's an abuse of discretion on his part to make that decision.
Well, I'm just logically trying to figure out how that applies in this situation.
Well, you don't have a crowd of Enfingers who are, saying, well, Knipper is way out here. This child's name is Knipper, and he knows he's the child of that man named Knipper because their names are the same. And so, it breaks down that barrier of we're all Enfingers and that's a Knipper way out there. That would be my argument.
Okay.
Okay. Now I know that we did not get to the other arguments in Mr. Grant's brief. I don't know if there's anything in particular anybody has any question about. Again, all of these go to the question of abuse of discretion. And I do want to point out that regarding the medical bills, that Mr. Knipper actually paid for more than one half. He paid $1,000 in Thanksgiving of 2017 in order to get Thanksgiving parenting time. He was required to cough up some money. And so he came up with $1,000 of small bills that he'd been receiving in tips where he'd been working as a waiter. And then before the hearing, he had paid another $1,200. So that's more than half of the $4,062.56.
What is the proof of the agreement? Apparently, the court found there was some agreement, and I'd like to hear what that proof was.
Well, I'm wondering if he's not talking about the stipulation about the amount, not that it had been paid, but that he had definitely paid the $1,000 at Thanksgiving. I can't really reconcile that, except to say that perhaps he was referring to the agreement being our stipulation on the amount. Because initially, Mr. Grant's right, it was listed at $6,000, but we agreed and stipulated there was actually $4,062.56. So, and there was no claim for any additional payment at the June 7th, 2018 hearing. Now, finally, on the material change of circumstances to modify the parenting time. Again, abuse of discretion. The court announced at the beginning that he had established the parenting time because it was based upon the young age of the child. He was acknowledging that there were limitations based upon that young age, and that in the near future, that because the child would be older, that he would consider a modification. This was a provision of the parenting plan. We put them in all the time. And so
excuse me, you mean to say the trial court basically says you don't have to prove a material change in circumstances?
Right. You still have to prove best interest of the child, but the child becoming more mature and time going by is a material change of circumstances.
Is that permissible for a trial court to change state law?
It's not a change of the state law. It's not inconsistent, because the child becoming more mature and being able to have more time with the other parent is a material change of circumstances. He would just—
That's making some assumptions, isn't it?
No, I think we all know very clearly that as a child matures, that changes.
Okay, thank you.
Thank you.
Mr. Grant, I believe you have 3 minutes. And as part of your 3 minutes, are you still requesting these medicals in light of what Ms. Middlebrooks has said?
I am, Your Honor, and the reason being is because the additional amount above the $1,000 we would argue that was regular child support. There's also not only the medical bills that were ordered to be paid, but also, or not ordered to be paid rather, but also retroactive child support back to the date of the birth of the child. So,
what did the trial court say about that?
No, the trial court was silent on retroactive child support. The trial court found that the $1,000 that father paid to mother was an equitable agreement between the parties, and the record is devoid of any such agreement, and the record is silent as to any retroactive child support. So,
Did you raise that as an issue on appeal, the retroactive child support?
I did, Your Honor. The retroactive child support and the medical bills are both raised under Roman numeral number 2.
Okay.
Yes.
And the trial court did if I understand you correctly, you're telling me the trial court did not rule specifically on the retroactive child support.
The trial court was absolutely silent on the issue of retroactive child support.
Okay, thank you.
Yes. Now, back to the name change. This court recently decided back in 2017 the Howell case. The Howell case is very similar to the case at bar. The main reason for the trial court's decision to change the child's surname in Howell was, one, the fact that the trial court found that the mother had thwarted the relationship between the child and the father. And based on that history, the trial court found that changing the child's surname to that of the father will further strengthen their relationship. This court found that there was no evidence to support a conclusion that changing the child's surname to father's surname would improve the relationship between the father and the child, and this court reversed the trial court's decision in Howell. This is very similar to Howell. Father's own testimony at trial, he testified himself that he did not believe that making the change in the surname would have a potential effect on his relationship with the child. When asked if having mother's surname would change the relationship with the child, he said, "I honestly don't know." The trial court based its decision on the name change solely on the previous history and the order of protection, evidence that was not introduced by either of the parties in the parentage action. The trial court has abused its discretion. It's applied incorrect legal standards. It's reached illogical conclusions. It's based its decision on clearly erroneous assessments of the evidence and employed reasoning that has caused an injustice to appellant. So we would argue that the trial court has abused its discretion and the decision should be reversed.
All right. Thank you, counsel. We appreciate your arguments. We appreciate you again participating in this process. I know it's new, it's different, and we're not all good at new and different. I'm not anyway. But we will do our best to get you an opinion as soon as possible. But we, again, appreciate everything you've done. And I think that concludes this case. Mr. Hivner.
The Honorable Court is now in recess until